Hey everybody, John Skiba here, and welcome to Thursday night. This is the Consumer Warrior YouTube channel, where each and every Thursday night we making sure the mic's working, make sure we're not having technical difficulties right out of the chute tonight. But yeah, welcome to Thursday night. This is where we do the live Q&A on the Consumer Warrior YouTube channel. Again, I'm John Skiba, founder of the Consumer Warrior YouTube channel, and I am a bankruptcy attorney and a what I call a debt defense. I help people who are being sued by creditors, attorney in the state of Arizona. And what I like to do each and every Thursday night, we do this live stream. We go over your questions, things that you're dealing with, whether it's wage garnishment, bankruptcy, debt collection lawsuits. My goal is to give you some resources and some tips that kind of point you in the right direction to be able to deal with this and be able to put all this, horrible stuff behind you. Like I said, I am a licensed attorney in Arizona, but my little disclaimer is that I'm not licensed anywhere else. So this isn't legal advice. This doesn't create any type of attorney-client relationship. That's a disclaimer attorneys use all the time. I don't know why anybody would think that we have an attorney-client relationship, because we're just talking on YouTube and you should take it for what it is. If you are in the state of Arizona, my information is below. You can set up a consultation. I do free consults for people in the state of Arizona. Even if you're not in the state of Arizona, check out the information below. I have some contact information and numbers where I can refer you to attorneys who do what I do in your home state. So I put in the chat section a couple of links. Many of you are aware of Solo Suit. Solo Suit is a great sponsor of our weekly live stream. I put a link there. They use technology to help with responding to debt collection lawsuits, debt validation letters, and even debt settlement. They have some really cool products. Click on that link. Go ahead and check them out, as well as the Consumer Warrior University. I have a ton of tutorials that I put together where I do a real deep dive into everything from representing yourself at trial to filing a motion to compel private arbitration, forms, templates, all that stuff. And then finally, a new company that I've been working with, Ascend Finance. They have these cool, really neat calculators. They're bankruptcy calculators to help you determine if you qualify for a Chapter 7. I have talked about on the channel a lot. To qualify for a Chapter 7 bankruptcy, you have to pass what's called the means test. It's one of the first things we go over when people reach out to my office. So I have you click on that link. It's just a free calculator that helps run you through it to help you to see if you're going to qualify. And they also have one that's really cool related to Chapter 13 bankruptcy. Chapter 13 bankruptcy is where you're going to pay back your creditors a portion of the debt over a 3 to 5 year period. I always go through Chapter 13, and the first thing people ask me is, okay, well, how much am I going to have to pay? It's a very factually intensive question. And so those calculators can walk you through that and give you an idea of what a Chapter 13 would look like, or a Chapter 7. So go ahead and check those out. I went through the comments over on the YouTube channel, and there's a couple good ones. There's more than a couple of good ones, but a couple that I wanted to go over because I think that they hit on themes that are probably come up with a lot of people. So this person said, if a debt buyer creditor, so this is in a debt collection lawsuit context, if a debt buyer creditor offers to dismiss the debt collection lawsuit without prejudice, what actions can be taken to compel the plaintiff to dismiss with prejudice? So just so we have our terminology, on the same page, if a lawsuit is dismissed, so the creditor, the plaintiff, they file their lawsuit, you file your answer, and you have this lawsuit that's pending. If the plaintiff or the creditor, they come to you and say, hey, we're out, we're going to be done with this, we want to dismiss, you want them to dismiss the lawsuit with prejudice. What that means is that they can't file it again. That if it's dismissed without prejudice, that means that they could refile it. So if they say to you, hey, let's just dismiss this thing, we're going to be done. But they want it without prejudice, they could dismiss the lawsuit, and then 6 months down the road, assuming that the statute of limitations hasn't expired, they could just refile it. So the question is there anything you can do to make them dismiss it with prejudice? Now, if you have not filed an answer, let's say they filed the lawsuit, they served you, and the time has not expired for you to file your answer, so you haven't filed it yet. If you have not filed an answer yet, in most jurisdictions, the rules of civil procedure allow the plaintiff to dismiss just as a matter of right. They don't have to have your permission. They're just going to file a notice with the court. Hey, we're dismissing it. no harm, no foul, we're done. And it's always dismissed without prejudice. You're not going to have any input in that. You're not going to be able to object to it. The court's going to dismiss it without prejudice if you haven't filed an answer. Now, if you have filed an answer to the collection lawsuit, if you've actually drafted it, used one of my tutorials, or you solo suit, you drafted your answer, you filed it with the court, the plaintiff is typically no longer allowed to just back out, because now you've got some skin in the game. You had to prepare the answer. Maybe you have an attorney. You filed the answer with the court, paid the filing fees, all that kind of stuff. Now, if you want to dismiss, they have to have your permission. They either have to file a motion and get the court to grant it, or they're going to have to get a stipulation from you where you're signing off on it saying, okay, I'm okay with that. So if it's the latter situation where they have filed the lawsuit, you've answered it, and they're asking you to stipulate to dismiss, this is where you can kind of put the screws to them a bit and say, well, it's got to be with prejudice, not without. And in most cases, they typically will agree. If they're just coming to you out of the blue saying, hey, we're going to drop this thing, there's something wrong with the case. You may want to have like an FDCPA attorney look at it, the Fair Debt Collection Practices Act, because if they're just trying to back out, that means usually they have problems with documents, witnesses, or they may have found something that leads them to believe it's outside the statute of limitations. And so they're nervous that you're going to find out about that. And then not only is it going to get dismissed, but then you may have a claim against them if it's a debt buyer. So those are the kind of things. I will tell you this. If it's just, if there is nothing wrong with the case and they're just dismissing, they don't want to bring it now, it's better to have the case dismissed without prejudice than not dismissed. I'd rather have it be done, because if it gets dismissed, even if it's without prejudice, all that time that the lawsuit was pending, that counts against the time when the statute of limitations is running. So the statute of limitations, you remember, that's the time from when the account goes into default that the creditor has to file the lawsuit. And if it's been too long, then it can be barred. So, and that kind of leads to this next question, which I pulled from the comments. It said, if you file a motion for the statute of limitations being up, so you're saying, okay, they file a lawsuit and you file a motion to dismiss saying, hey, judge, this debt collector has filed their lawsuit. It's outside the statute of limitations. And let's say in this, so the judge agrees and says, yep, it is outside the statute of limitations. So this case is dismissed. Does it go on your credit? So there's two different competing things going on here. So the statute of limitations, it deals solely with the ability of the creditor or the debt buyer, the debt collector, whoever's bringing the lawsuit. It deals with their ability to file a lawsuit against you. So if the statute, so for example, in Arizona, the statute of limitations on a credit card debt is 6 years. So from the time that the card, the payments stop on the card and it goes into default, the creditor then has a 6-year window to file that lawsuit. If they don't, they're barred forever from doing it. So in a case like this, they filed the lawsuit and you're like, hey, it's been more than 6 years. And I should tell you, the statute of limitations varies from state to state. So depending on what state you are, you need to do a little research on this. A good place to do that, by the way, I found this whole AI revolution, ChatGPT or Gemini. Those are good places where you can at least start and get some ideas of how long the statute of limitations is on a credit card matter in your state. So, if it's out, so they file a motion, it gets dismissed. All that means is that they can't sue you anymore. It does not impact how it's going to be reported on your credit. Information about the account can still be in your credit, and derogatory collections. Those are going to be on there for a little over 7 years, regardless of whether the statute of limitations has expired. So it's also important to know. So in a case like this, where the case gets dismissed because the statute of limitations has expired, the creditor could still turn around and ask you to voluntarily pay it, but they're not allowed to sue you for it. So if you kind of say, because the debt's outside the statute of limitations, doesn't mean the debt just goes away. It just means that they don't have their, what do I call their hammers? They don't have anything that they can, because without a lawsuit, they can't get a judgment. Without a judgment, they can't garnish your wages. They can't do bank levies, all that kind of stuff. So hopefully that is helpful there. Let's see. Any other questions? Ghetto Daddy says, best YouTube channel ever. Thank you. Hey, and if anybody's watching this, please subscribe. I know I'm probably preaching to the choir here, but if you haven't subscribed yet, go ahead and do it. We're getting up to, we're over 40,000 subscribers now, which is crazy. the number of people that have subscribed. So I always appreciate it. Your question. Goldman Sachs, Apple Card, offered a 50% settlement, but I'm holding on for a lower settlement in the 20 to 30% range. Credit card debt is $6,275. What's your experience with them? Think they'll budge. So the important thing to understand is kind of the cycle of collections and how that impacts your ability to get a lower settlement. So once you stop making payments on a credit card, it'll go 180 days of internal collections like Goldman Sachs. So you have the Apple Card, no payments have been made. During that 180 days, during that 6-month period, you're going to get phone calls from Goldman Sachs. Maybe they're going to hire a collection agency. And maybe that collection agency will hire another collection agency. And they'll keep calling and trying to get payments or different kind of payment plans. And then once it hits 180 days, 6 full months of no payments, they've got to charge it off. And so the charge off, again, if you watch the channel a lot, I talk a lot about charge off does not mean that they cannot continue to try to collect on it. They can. But what they do, that's a tax classification where they're counting this as a loss on their books. They're saying it's not collectible. And so depending on who the creditor is, so Goldman Sachs, they will likely package this up in a portfolio of a bunch of other debts, and they'll sell it on the open market to companies called debt buyers. Companies like LVMV Funding, Portfolio Recovery, Resurgent Capital, Encore Capital, Unifund, all these big debt buyers and they go and they pay pennies on the dollar for the rights to these accounts so that they can sue you, get a judgment, and garnish you. And so the way they make money is they pay 4 or 5 cents on the dollar. They sue you. If they get a judgment, they get to collect 100 cents on the dollar, and that's how they make it work. So do I think they'll budge? I go through that because do I think they'll budge? Original creditors often do not. They usually want more, particularly if they're the type that keeps the debt and sues it. Now, Goldman Sachs usually does sell their debt. Companies that don't, American Express, they usually keep their debt and they sue it, and they're very aggressive. I think American Express is the most aggressive. Discover Bank, they often keep their own debt and they'll sue on their own debt. But the Citibanks of the world, Synchrony, the web-based ones, Lending Club, those things, they typically sell their debt to debt buyers. When it gets sold to a debt buyer, you're going to get those lower settlements. In a situation like this, my experience is if you're in that first 180 days still with like a Goldman Sachs, your best bet for settlement is probably going to be about the 4-month mark right before it charges off. And you can, I don't know if you'll get it down to 20%, but if you can get anything less than 50, I would probably take it, particularly on a debt of that amount, just to get it out of your life kind of thing. So, all right, let's see what Atlanta, Georgia has to say. How important is the evidence of agreement in a debt collection lawsuit? So when they file suit, here's how to think about it. If it's there's a handful of elements that the plaintiff has to prove. And you got to kind of get this into your mindset. When a plaintiff files a lawsuit against a defendant, the plaintiff has the burden of proof. They have to establish all of the elements of their case. Typically, it's a breach of contract. So breach of contract is they have to show that you entered into an agreement. They have to be able to show what the terms of that agreement were. They have to show that you breached it, and then they have to show what their damages are, how they're calculating the amounts owed. If a junk debt buyer has bought it, they have an additional element. They have to show that your account was specifically transferred to them. And that gives them the right to be able to be there and sue you, even though you didn't have a contract with them. And so how important is the evidence of the actual agreement? If it's a debt collection case, if they don't have any type of agreement, the days are gone where if you're older like me, a lot of people probably don't even remember, but they used to send you credit card applications in the mail. And you'd fill out the little card and then you'd send it in. And then, 3 weeks later, you'd get something back. Hey, you got approved, or no, you didn't. So, and then they would keep that. They would actually scan that in. So they have the application you filled out manually. And then, that's your contract, your signature was on it. I don't believe they do that anymore. I haven't seen it. Everything's done online. And so you get, often what you get in a debt collection case is you get the terms and conditions and then some type of, monthly statements. Usually what they have is they'll provide you with a copy of the terms and conditions that relate to that card. And that may be enough. there are many jurisdictions, like Arizona has this, where they can use the monthly statements as proof of an agreement. Essentially, if there's payments and purchases and payments and purchases and your address is on there. So they can also sue you under what's called an account stated theory, where they're showing that there's been this course of dealing between the parties. So if they don't have the actual agreement, or if they don't have the actual card with your signature on it, it's probably not fatal to their case. They can still probably prove their case through a course of dealing. Now, the thing that I always object to, I had a case just recently with Midland Credit, where they're alleging this course of dealing on a card that had been open for 10 years, and they provided us two non-sequential monthly statements. That doesn't show a course of dealing. And one of them is the charge-off statement, which doesn't show any payments or any purchases. And so you want to look at that. If they're trying to allege, hey, we're going to prove this case by showing this course of dealing and these monthly statements, and they provide you with two statements, and one of them has one charge for $150, but they're suing you for 10 grand, all that stuff, that's not sufficient. And that's where you need to press them on the issue. All right. Alex, thank you, from Yuma. I got my Arizona guys. It's actually, I'm looking outside. It's starting to feel like springtime in Arizona. We're already in the mid 70s. But if you're in the mid 70s at the end of February, that means things are going to be brutal this summer. Alex, down in Yuma, where it's much, much worse than where I live as far as the temperature goes, says, in filing a motion to compel arbitration, what are you asking the court to do with the complaint? Dismissal or stayed? And this goes to often these credit card agreements that we're talking about, they will have an arbitration provision in there, which allows the parties to take the cases out of the court system, the judicial system, and have a private arbitrator deal with it, like AAA, American Arbitration Association, not the American Automobile Association. AAA, American Arbitration Association, and essentially it's kind of like hire a judge. It's a private company where you pay them to be the judge. So you can, and we've talked a lot in the channel about why you would do that, but you can file this motion to compel it. And my views on this have evolved a bit, because I used to always file a motion to dismiss and compel private arbitration. And I still do file a motion to dismiss. However, a lot of courts are going to say, look, we're not going to just dismiss it outright. You're going to have to, we'll stay this. We'll stay the litigation for 90 days. That'll give you time to go file your motion to compel arbitration. And then if you don't do it, if you don't file your motion to compel, or if you don't file your arbitration, your private arbitration proceedings, then we can come back here and we can finish it that way. So the way that I do it in my practice here in Arizona is I file a motion to compel private arbitration. Once that's granted, even if the court just stays it, then I will go ahead and file my arbitration with AAA. And then I go back to the court and I file a notice and include my case number saying, hey, look, it was filed. We filed the arbitration hearing. And so we're all squared away there. So good question, Alex. You got one more down here. We'll just do it. Talk about judgment on the pleadings. Would you ever pursue one? So judgment on the pleadings, if a creditor files a lawsuit, they often try to use this against you. So they file a lawsuit, their complaint has all their allegations of the case, and then you file your answer. If you admit to everything in their answer, because you got to look at, so there's all these allegations in their complaint, and then in the answer, they want to know, do you admit or deny what it is that they're alleging? If you just admit everything, then you're going to get hit from the plaintiff with a motion for judgment on the pleadings, where the judge, the other side saying, look, judge, there's no dispute here. We don't need you. Just tell us we win and grant judgment. And if you did admit everything like that, yeah, they're going to grant that. Can you use that against the debt buyer? Likely not. The reason why I say that is because like Arizona is what's called a notice pleading state, where their complaint, all it really has to do is put you on notice of the allegations that they have against you. And if you don't feel that their complaint is, if there's not sufficient facts in there to even establish a claim against you, your option is really to file what's called a motion to dismiss, where you're saying, hey, there's something defective in the actual complaint itself. They named the wrong person. Even if there's a dispute or whether you had the account or whether they own the account, that's likely going to have to be dealt with, like with a motion for summary judgment or even a trial. So that's typically how I would approach it. All right, Drew says, what are my thoughts on green versus portfolio recovery? Oh boy, I clicked on this and I'm not familiar with the case. You might have to bring me up to speed on that. This is going to be some big case that I should have known about and I didn't prepare for. So Drew, I'm sorry about that. I'll have to check that out and maybe I can do a video on it down the road. So, all right. Well, hey, everybody, thanks for checking in tonight. I've actually got to head out a little early tonight, but I appreciate everybody checking in. I just released 3 new videos on Chapter 7. I'm doing a 7-part series on the Chapter 7 process. If you're thinking of Chapter 7, go ahead and check that out. If you're in Arizona, give me a call. We can help you. And check out some of the sponsors here. Solo Suit, Ascend Finance, and the Consumer Warrior tutorials. They can be very helpful. Appreciate all your support of the channel. We'll catch you next week.